All right, well, good afternoon, everyone. I am Amy Dickerson, and I'm here with my partners, Nicki Bazer and Dana Fattore Crumley. And welcome to our webinar this afternoon, the first in many that we have planned in the coming months to provide school administrators with focused, succinct guidance on a narrow topic that is top of mind for school leaders. So today we will be focusing our discussion on curriculum objections, identifying the top 3 key considerations for schools when establishing your school's procedures for reviewing curriculum objections and best practices for processing such objections. So this is a topic that we have received increasing questions about from districts, and we anticipate seeing even an increase of these types of objection requests in the coming year in light of the current climate. And as a result of receiving some of these, we've also noticed that there is a certain level of confusion and misunderstandings from parents and community members around what parents do and do not have a right to object to, and around what parents do and do not have the right to request their children be opted out from when it comes to the curriculum that you're providing in your schools. So our discussion today will start with providing an overview of the legal parameters for curriculum objections, and then we will identify the key considerations for school district policies. We'll then close with a discussion on best practices for implementation and processing objection requests. We are also happy to take any questions that you have. So please submit your questions through the Q&A function on Zoom. It is much easier for us to keep track of and answer questions there than in the chat. And then if you have any follow-up questions after the webinar, of course, as always, please feel free to contact any of us. So with that, we will get started, and I will turn it over to Nicki to give us sort of a further introduction on the topic and then an overview on the legal parameters for curriculum objections.
Yeah, absolutely. And thanks, Amy. I do think you're absolutely right that we are going to see an increase. We're already seeing it. Obviously, there's been a lot in the news outside of Illinois. I think we've seen some objections. We had a question come in advance of the webinar about, do we expect to see more on the critical race theory front and other challenges as well? I don't anticipate these slowing down. Hopefully, they're not going to become endemic, but I do think that we're going to see more and more. Obviously, we've seen one actual federal court case related to equity curriculum, and we've seen some challenges around the state based on various books that teachers are either teaching or in libraries. So, hopefully, again, we're not going to see too many more, but I don't expect it to slow down immediately. So I do want to start with not going too far down the rabbit hole of the law, but just to give some general parameters to think about, and just when to sort of call your attorney kind of moments. I would say first, generally, districts have broad discretion to select curriculum. Courts have, all the way up to the U.S. Supreme Court, have confirmed this in multiple cases going back decades, and courts are generally reluctant to intervene in the resolution of conflicts that arise in the daily operations of school districts, and that includes things like curriculum. I will say that this sort of unfettered or broad discretion is confined by a couple of things. So first, obviously, there are requirements in the school code. So districts have to teach certain curricular items. They have to include in those broader topics specifics depending on what the school code provides. We know, for example, that there are various history requirements, there are various requirements related to sexual education. So obviously, districts do need to follow the school code provisions when they are offering those curriculum pieces. And obviously, they need to be aligned to the Illinois learning standards. And I know Dana will talk about a little bit about that as well. They are also confined by, courts will intervene when a district, when there's a challenge to a district's curriculum piece, when there are constitutional rights implicated. And so generally what we're talking about there are First Amendment rights. Courts have intervened when teaching's curriculum pieces are in violation of this Establishment Clause. So for example, if a school district is teaching something that has a very specific religious component, not generally teaching about religion, but is advocating or advancing a specific religion, courts have stepped in then and said, no, you can't teach that. I will say that they've been more reluctant to intervene in the reverse. So let me explain. When a parent has challenged what is otherwise a secular curricular topic because they believe that it interferes with their or their child's religious freedoms or beliefs, courts have been more reluctant to intervene to say that a school district can't teach that. We will talk a little bit, I know Dana will talk a little bit about individual challenges or individual requests to opt out based on religious grounds, which districts may have to entertain. But we don't see a lot of courts saying you can't teach this at all across the board because it may interfere with an individual parent's or child's religious belief. Another nuance to think about in the world of First Amendment is that courts have also recognized that students have a First Amendment right to receive information. And so while that may not necessarily impact your curriculum, it might actually implicate removal of library books. So if districts are removing wholesale, specific topics or library books, there have been some court cases, including a Supreme Court case, that dealt with that issue and whether or not students have a right to at least have access to that information, even if, especially when it is not required. So all of this to say that, and what I think we want to set up with this legal discussion is that all of these challenges that are coming in where parents want to opt out of this book or this piece of the lesson plan, in many, many cases, districts will not have to grant those requests. Really, the district should, maintain and have the discretion to implement the curriculum that they want. Obviously, if we see a religious objection or First Amendment objection, you're going to want to make sure that you're touching base with your attorneys, with us. We're happy to talk through those to make sure that you're not running afoul of anybody's individual constitutional rights, while also maintaining your right to provide the curriculum that you want to provide. So this is a really complicated area of law, lots of constitutional issues, but I think that gives a little bit of a framework to set up to toss it to Dana to talk a little bit about how to think about then what to do about policy and how to implement.
Thanks. So what I take away from your overview there is I cannot object to the multiplication of integers.
You can't get out of math, Dana. I'm so sorry.
Right. Okay. So that's good to know. I think I'm just making a little joke there because I think that's sort of the biggest problem in this area right now is that parents have seemed to lost their way in terms of what they can object to and what they cannot object to. And I don't know I don't know the reason for that right now. I don't know if it's the political climate. I don't know if it's the fact that the pandemic has sort of made school sort of like people have forgotten how to do school, and like school is, just not things that we make up off the top of our head, but really based firmly in, free public education is part of the Illinois Constitution. It's part of continuing the democracy. There are certain standards and curricular areas that we cover, not just so people can like graduate and go to Harvard, but so that they can participate in our democracy and understand the things they need to understand to be independent, functioning citizens.
Dana, I like to describe it as public school is not a la carte.
It is not a la carte, exactly. It is not like the menu at Panera Bread. It's there is a purpose for it and a reason for it. And I think when you look at the policies that school districts have, because I mean, honestly, we don't look, prior to this time, we did not look at these things too often. People have always, since the beginning of time, gotten upset about sex ed. Well, let's just put that out there. So we always have a few of these. When we send the letter home saying we're going to do a unit in health on sexual education, we get a few of them. So, and I think the policy sort of covered that. But I don't think the policy has contemplated all of the other objections that Nicki referenced to certain pieces of literature, critical race theory, some of the new requirements. We had a question about Aaron's Law, which we will cover. And we're just seeing these on a much broader basis. And I think the policy, as it's written, most policies that we've looked at, do give parents this incorrect impression that you can just object to things, that it is a menu, it is a la carte. if I don't think something is useful for my student, or it offends me, or I think it's about something that my student doesn't need to know about, or it conflicts with any belief system I have, not necessarily a religious belief even, that I can just say no. And you can therefore put me in another room and give me an alternate curriculum, or let me watch a movie or whatever. And that's not the case. That does not accurately describe the law. So when we're talking about what should a policy have that's a little bit more robust and will be more informational to parents about what these rights are and, the limitations and how to exercise, we're talking about a policy that really starts from like a very broad basis. Like, what is the curriculum? How do you design the curriculum? Elementary schools and high schools have a little bit of a different flavor as far as the districts, but usually there's some sort of mission statement in there about, the curriculum is based on Illinois state standards. And, there's, committees, or there's a process, or a group of teachers, best practices, other things that you weave in that your community is determined that's appropriate to set what the curriculum is. It's usually related to the educational mission of the district and the outcomes that you want for students. And I think it's important to articulate those. I mean, when you think about some of these areas of focus, diversity education is important for many reasons, but it is important because we're trying to graduate people that are going to be productive members of society, and society is diverse. So making those connections, as I say, making the theme very easy to understand. We're thinking Oliver Stone, not, Italian art film, as far as why we're doing this. That's very important. The policy, I think, is also helpful to sort of reference the specifics. Where are the specific areas that you can object to curriculum? And we talked about sex ed, that's a big one, dissection. Those used to be sort of the big two, but now there's more. And you can object to organ, tissue, and blood donation. I wish I was a little, like fly on the wall to see how these got in the statute. Don't you, Nikki? Like, was there a person that was just really grossed out by like blood donation or something? There's some religious basis for that. I don't want to minimize it, but that is an objection. CPR AED use. If you don't want to learn about how to use an automatic external defibrillator, you are not required to do that. Obviously, lockdown drills, which I think some very serious valid concerns were raised about lockdown drills by the IEA and by parents and different groups. And then obviously the religious objections. Using the standard that Nicki described, which I think, Nicki, is more than just my religion. What would you treat like my religion doesn't believe in homosexuality? Is that enough of a religious objection?
No, I mean, I think you really have to articulate why the specific piece of curriculum or the course would interfere with your religious beliefs, and it has to have a direct connection. So that analysis, I think, really, I mean, the parts of the school code where you're talking about, Dana, where you have an automatic right to opt out, I think it's pretty straightforward. That one, if you get objections, I think it's worth having an attorney look at it, because I think there is really needing to be that intersection.
Exactly, and that sort of leads to the next part of the policy is, are you going to have a form for objections? And we do recommend a form because that makes parents articulate, just not generally, the Catholic Church is not in favor of this, so therefore I won't learn it. That is not enough. You have to show how that material is inhibiting you from practicing your faith. And I mean, if you're using Catholicism as a good example, these are things that Catholics study and Catholics learn in universities. So that right there is not going to get you to the place where there's a valid religious objection. Having some sort of opportunity for legal review if the analysis does need to be more detailed than perhaps what you can do in-house. And some of these establishment clause challenges or freedom of free exercise challenges are hard to wade through. It's really dense case law. And it's really fact specific. So it does warrant a little bit of legal advice in those situations. Then also just think about your policy. What role do teachers play? We don't want to leave teachers out of this. I think that, sometimes parents are questioning things and they're concerned about things, but I think a conversation with the teacher about why we're studying this, why we're reading it, what the context is going to be for it, what resources are going to be provided to families to support the curriculum at home, how the student will be supported if they have questions, and like how the discussion is going to be structured, just so that differing viewpoints are going to be protected. I mean, these are all super important things that I think can actually enhance trust in your educational program if you empower teachers to talk about these things and really have them articulate, you know, sort of the good work they're doing in these curricular committees and explain that to parents and explain the rationale for it. I think allowing that teacher input also allows you to make exceptions for special situations. And I'm not saying you want to do this all the time, because I don't think that, again, I think it's very fact specific. But, you know, as you get to the older grades, and older grades are reading books that might have depictions of traumatic events. If you had a student, for example, that was sexually assaulted, and the parent said, I don't want them to read this book because then that's not necessarily a curriculum objection, and I wouldn't put it through. I'm curious as what Nicki and Amy think. I don't know that I'd put it through that process. I see it more as an accommodation of that student based on, you know, a life experience or something that would be, you know, if they're traumatized and they need to have this, it's an accommodation. It would be under Section 504. Maybe you're not going to do a whole plan, but I like it sort of framed in that way rather than an objection. What do you guys think?
That makes sense to me, yes.
Yeah. So going into some of our questions, and of course we welcome questions from the people that are participating. So we had a question specifically about Aaron's Law, just to refresh everybody, because there's not a lot of laws now named after students, which is going to really pose a challenge to those who used to be teachers like me and like can't keep people's names straight. But Aaron's Law is really about giving kids, making them aware of sexual harassment and sexual abuse and how they can report that and how they can have agency and prevent that from happening to them. So very good thing, but can parents opt out of it? Because it is related to sex abuse, yes, they can opt out of that. So there is an opt-out for that law. And all the, you know, anything that touches sex ed under that's recently been sort of revised, and the statute has been updated, and we were giving a lot of advice on that. That would be an area where you do need to take those objections very seriously.
Yeah, so, we also got a question in about the difference of advice for syllabi, what is considered district approved curriculum versus student supplemental. And we got a question in sort of simultaneous on the chat about you know, objecting to libraries and books in libraries. So I kind of want to talk about them at the same time and quickly, because I want Amy to get into some of our practices that we would recommend. But you know, I think in terms of district approved curriculum, again, I think you have a lot of discretion over that. You know, short of the specific curriculum objections that are required under the school code that Dana just went through, short of a viable religious or constitutional objection, you know, what's on the district approved curriculum on the syllabus, you know, would be something that the district could require. In terms of student supplemental, what I take from that, you know, if you have like a reading list that's you know, optional for students, you know, and also books in the library, right? If they're volunteer, if students don't have to do it, I don't know that there would be a viable objection from a parent. And I do think in terms of libraries, as I mentioned at the beginning, there is some case law. And again, we'd want to talk the specifics of the scenario that you were facing, but there is at least some case law out there on the fact that students have a First Amendment right to receive information, and that would include potentially books in the library and potentially a supplemental reading list. I mean, presuming that you are looking at the fact that books are, you know, grade level appropriate, you're taking them off of lists from professional organizations for school librarians, National Council of Teachers, that sort of thing. You know, I think any objection to a voluntary list of books is really not a viable objection. If the question is whether teachers can themselves decide to stick books on that without district approval, I would say that, we'd obviously want to look at your policies and your CBA. Typically, teachers, particularly elementary school teachers, don't really have a lot of leeway when it comes to curriculum. They really need to just put forth the district's curriculum. So I'd like to see, a reading list coming out of the department or the grade level, rather than teachers sort of doing it on their own. But again, we would have to sort of look at the specifics of the facts, but I think schools have a lot of discretion in these areas. So I will turn it over to Amy. I know we have just a few minutes left to sort of run through some practices.
Yeah, so I'm just going to provide, an overview of some best practices for implementation and processing requests in light of the considerations that Nicki and Dana just went through. So, really having a clear protocol and supporting documents to implement your school district's policy and to process objections or requests for exemptions will really allow your team to be prepared when it receives an objection or exemption request, and will allow it to review and respond to it in a methodical, legally compliant manner. So we recommend taking the time now, to compile these materials so that you have them prepared when you do receive these requests and don't have to be, sort of hurrying to do that. Of course, we're here always to assist when you do get those in. If you don't have all the particular steps required, it can walk you through that. But having those things in advance, it can really help to support your team. So we do recommend certain key components be a part of any district's curriculum objection protocol. And I'll go through these components now. And for those interested, we are also going to be offering a toolkit that will contain templates for these various components. So first, having a clear policy that does not describe parents' right to object too broadly is critical for the reasons that Dana discussed. And we have actually reviewed and recommended revisions to the model policy that's used by many districts to more narrowly tailor it to include the components that Dana identified that we recommend. And that would be included in any toolkit that we offer. But if you're not using that revised model policy, having legal counsel review your existing policy to ensure it is not overly broad and contains the recommended components would be advisable. We also then recommend having a form, as Dana mentioned, for parents to complete when raising a curriculum objection or seeking an exemption from certain curriculum or educational programming. The form should direct parents to clearly identify the basis for their objection, identifying whether it's for a religious purpose or if it is pursuant to a statutory right to object, such as those that we've already discussed that are expressly laid out in the school code. And the form should reiterate the basis under which a parent may request an exemption from their child participating in certain aspects of the curriculum, making clear that such exemption requests are only available in limited circumstances. And while this is language that we would also recommend be included in your board policies, we know that parents aren't also always going through those board policy manuals and reviewing that. And so having a form and having some introductory language in that form that sets that out is really an opportunity to remind parents of what the policy is and what the circumstances are that any objection that they're planning to make are really going to be able to be granted or not. Having also a clear protocol then to follow when processing such requests are made is really key to having an internal protocol for your staff to follow. So districts should have a clear process first for informing parents of the need to complete a form when making any objection requests, so that process can be done in a uniform, methodical way, and then identifying a particular staff member or staff members to process such requests, and then providing them with training to do so if necessary. You should also then inform all teachers of this process, so that if a parent brings an objection directly to a teacher, then the teacher knows how the administration expects them to address that, such as perhaps having a conversation first about the relevance of that particular topic to the curriculum, as Dana described, but then also to support your teachers to let them know where to direct direct the parents to if they do wish to make a formal objection, and who that staff member should, where they should go, so then they can get then that form if you have that as part of your process. Such staff members should then, any administrator who's then going to be the one processing these requests should be provided with a rubric or flow chart for how to review, analyze, and make determinations regarding such requests. Or at a minimum, just be sufficiently trained on the steps that they should be taking when reviewing those requests. So for example, any sort of training protocol or a rubric would walk administrators through the questions that need to be answered to know whether a curriculum objection must be granted or not, such as, does the parent clearly identify in the form the aspect of the curriculum to which they're objecting? Does the parent clearly identify the basis for their objection, what it is, and if it's either a religious basis or a basis for which the school code or other statute or school policy expressly permits a parent to object? If not, then the exemption request would likely be appropriately denied unless the form itself isn't asking, the right questions, in which case then you perhaps might need to go back to the parent to get more information. If it does identify such a basis, then the rubric would, identify the key questions and issues to assess to determine if it can be granted. For example, if they make the request due to religious reasons, is the basis for which the parent is articulating their exemption request sufficient that the exemption request must be permitted? And then the rubric can spell out how the administrator should make this determination. Of course, as we've discussed, especially for those requests based on religious reasons, that's often going to, it's often going to be advisable that you incorporate legal counsel to help assist with that. But having something in place to help at least process these things initially can be really beneficial to spot check these issues, perhaps to identify if initial or additional information is going to be needed from the parents. If the parents make a request pursuant to a statute that expressly allows them to opt out their students from participating in that program, a question to ask is, do they include all the necessary information to make that request? If they do, then you're likely going to be granting that request. And then the rubric should also identify when the district must provide alternative programming if an exemption request is granted. And this could also then assist the district in maintaining a record to ensure that that alternative programming has in fact then been provided, especially when our statutes require that that be provided if a parent is opting their student out, and to make sure that then we're keeping track of that. Our toolkit would also then include an example of a rubric that I've gone through, like the one I've gone through, that administrators can use that would include these various components. But of course, we can also assist administrators with training to go through these processes as well. And finally, we also recommend having a template ready to go for the communications to parents regarding the outcome of their particular request. Something that, again, our toolkit would also include. So this would be communications both for when you are denying a request and as well as when you are granting a request. And for those requests that are denied, the communication should include an explanation of how a parent can appeal that denial should they choose to do so through the district's uniform grievance procedure. And then districts should also just ensure that they do have an internal protocol set up to ensure that any teachers necessary to know the information about whether a student is going to be opting out of the particular aspect of the curriculum, making sure that the necessary teachers have that information and know how to address that.
So I think we just had one question come in to the chat, Dana, that I thought you would tackle quickly, and then we can sort of summarize.
We have a few more. So yeah, we can summarize. So one of the questions was any input on best practices and navigating freedom of speech claims that may come from teachers. So, teachers don't really have like extensive freedom of speech when they're teaching in the classroom. They have freedom of speech when they're not teaching in the classroom. And, I know that parents think that teachers are, the left-wing, communists sometimes, but they are, really good teaching is neutral teaching. It's presenting opposite viewpoints. So I think you need to instruct teachers, and Nicki actually did a very great presentation in one of our clients, helping teachers understand these boundaries. And we do have a presentation on that. So if that's something you're interested in, please reach out to one of us.
Yeah. There was also a question about whether is considering objections of books, is age appropriateness a reasonable objection? And I would say no. I mean, if it's a required book that the department, the school district has decided is going to be part of your curriculum, the fact that the parent is concerned about age appropriateness, I do not believe would be a viable or appropriate objection, unless it was in one of the courses that we've already talked about, that they have an automatic opt-out right.
And I think that's something that you addressed earlier, that we addressed earlier on, or Nicki referenced, is that like the American Association, or whatever their group is, the school librarians and the National Council of Teachers of English, they're really weighing in on what is age appropriate and how the books are written and the reading levels and the messaging. And so those are the standards that you're going to be referring to when you have complaints like this. But that wouldn't be a valid legal objection. I would agree with Nicki.
And I would just add to that, I think some districts' current policies allow for parents to submit suggestions in addition to objections. So I might put that in that camp of, if there is feedback provided about whether something is age appropriate, to view it as a suggestion, perhaps to review with those particular departments, as opposed to something that is an objection, that can serve as a basis for a parent to opt out their students from participating in that particular aspect of the program.
Yeah, I think that's a great idea, Amy. I see we're at time. I do want to just mention, Amy went through in some detail the idea of some of the pieces that should be in place, and we do have a toolkit. You can reach out to any of us, any of your Franczek attorneys, and we can help, or you can reach out to marketing@franczek.com. So if you are interested in the toolkit, again, Amy ran through it, but it's the policy, the curriculum objection form, some of the parent communications, and the rubric, I think, are really those essential elements. If you have other questions that we weren't able to answer, feel free to reach out to any of us. If we can assist your administrative teams in any way, we're happy to do so. We will be back again in April on the third Thursday of the month for 30 minutes to discuss restraint and timeouts, another topic that we know is top of mind for you all administrators. So we do appreciate you being here, and we will see you next week.
Take care, everybody.
Bye.